Speaker of Parliament Jacob Oulanyah has for the first time weighed in on the pending debate seeking to refuse bail for serious offenders. Acknowledging a bruising political battle ahead on the floor of Parliament, Oulanyah has given assurances it will be objectively handled.
Here discussion on bail matters. It's a very hot topic now. I think it's going to be hot when it comes to Parliament. But we have the capacity to find a solution that will be balanced.
Oulanyah's comments were prompted by state prosecutors who claimed that despite their critical role in the criminal justice system, they have been left out in the entire debate.
Each accused has like 2 lawyers, and you expect this prosecutor to effectively prepare for those applications. The information to get from the public, from the victims, which you use to prepare, we have what we call affidavits, which we gather as evidence to prepare before the court to object to the bail. So you find you have not even enough time to do that. So it is understood that when you go to court, definitely you are not fully prepared.
Oulanyah cited a lack of confidence in the criminal justice system as the driver of the proposed amendments.
We have to deal with the concerns of the public. The biggest thing that they are faced with is that each time somebody is brought into the criminal justice system, that person is ejected immediately back into the community, and there are challenges. The victims don't feel good, and they shout and they cry and they talk to politicians and they talk to leaders, and most times they resort to what you call mob justice.
It's wrong to legislate based on that purpose. After all, in our laws, it is lawful to have a prosecution of a criminal case done, even in a single day or 2 days. The state will now put a lot of energy and power and a lot of all this money they are spending in terms of empowering investigative agencies like the DPP and police and the CID, among others.
As Parliament, we should oppose any attempts to remove bail. Bail is a constitutional matter. Bail is a right, and the judges and the judiciary have been given, leeway by the Constitution to manage it in a way found appropriate.
Article 23, Clause 6A of the Constitution provides for the right of an accused person to apply for court to be released on bail, subject to the legal requirements and the conditions which must be fulfilled before court grants bail. Article 23, Clause 6B gives the accused person the right to be released on bail if the person has been remanded for 60 days before trial in respect of an offense triable by the High Court or subordinate court/magistrates court. And Article 23, Clause 6C gives the accused person the right to be released on bail if he or she has spent 180 days on remand in respect of an offense only triable by a High Court. The state prosecutors petitioned Oulanyah over low pay, working conditions and lack of state security, despite handling sensitive cases.
The lack of facilitation in terms of transport, computers, medical insurance, decent accommodation, etc. Prosecutors suffer embarrassment of using borders, residing in slums, eating in contemptible hideouts, and sometimes going without food.
We understand that the Witness Protection Bill is within your building. We pray that you help us and fast track it to enable us being protected. Not only prosecutors, but even judicial officers. And this is hindering the criminal justice system.
In 2017, the state prosecutors went on strike over poor pay. However, despite negotiations with the president, the matter is yet to be resolved. Habad Ziwa, NTV at Parliament.